So what happens when you go through the process? There's been a write-down possibly or a considered write-down of the value of the property. That loan comes up for renewal. Is it just a topic of negotiation at that point?
Well, if the asset is worth 30% less, it may just be unrealistic to keep that property because the money is going to have to come from somewhere. Is the borrower going to want to contribute from their pocket the equity to make the difference? It might be a situation where the borrower decides it's easier to give the keys back, give the property back to the lender, than to put in more cash. Maybe they already have very high leverage, so the landlord may not be losing as much money as it sounds like. If the property was worth $100 million and the loan was $80 million, and now the property is worth $70 million, maybe the landlord's only down $10 million and doesn't want to put in another $30 million to give them that equity cushion. I mean, that's sort of rough math, but that's what's taking place across the country.
And most of the time, these are single-purpose entities that own that building, so there's no ability to get after other assets beyond collecting against that building?
Yeah, typically these loans are non-recourse. The lender has recourse against the property, not against the individuals. So when the borrower does throw the keys back, when we say that, that means a deed in lieu of foreclosure. They convey the property back to the bank instead of the bank foreclosing. It's faster, it's more efficient, doesn't cost as much money, less bad publicity, things like that. But there often are tax reasons why that may not be as easy as it sounds. Depending on how the loan was structured, there may be a significant tax hit for the borrower to convey that property back to the bank.
Now, your role as a lawyer involves financing transactions, but also doing leasing but mostly tenants, but also for landlords as well, right?
Right.
How does this change in the economy affect the tenants market when you're negotiating on behalf of tenants?
If you're representing a tenant in this market, you really need to do more due diligence on the loan situation than you ever would in the past. If the landlord has shaky financials, you could try to negotiate where the allowance money is escrowed. That's a really tough thing to negotiate. It's very complex, a lot of parties involved. You could try to get offset rights for that money where if the allowance is not paid to the tenant, they can offset that against future rent. But that gets complicated because the bank's got to approve that as part of a three-party agreement. If the landlord is offering generous concession packages, which is market now, landlords are giving years of free rent, very high tenant improvement allowances. So if you're the tenant on a sizable deal, you don't want that concession to be at risk if the landlord becomes the bank during your term. That's a really significant issue. On smaller deals, maybe you don't have that leverage, but you still should be concerned about it. So it's a real challenge, but you really need to be aware of that and talk to your client about those issues.